Great. Welcome to the House Healthcare Committee. We have a Legislative Counsel, Michelle Childs, with us today. And as you remember, we've been having some questions about like what's litigation, what's an H89, which is the companion to S37. So we are not doing a full walkthrough, but Michelle's going to walk through some sections that are, or summarize sections that are pertinent to us, and then we can ask some questions at the end. So I'm going to turn it over to you.
Thank you. So good morning. And for the record, Michelle Childs with Legislative Counsel. And I see some faces that are new to me. So
yeah, and then we'll do introductions as well. So go.
Okay. So I just want, I have been here about 25 years. Worked my way up from an intern to a law clerk, and finally they let me stay. And I work as part of the judiciary team along with Eric Fitzpatrick and Ben Novogroski. And I cover family law, so all like marriage, divorce, child custody, things like that. I also do a number of issues in the criminal law field. So I cover all the domestic and sexual violence issues and then a smattering of other things. I work on the drug laws. So I've worked with Representative McFawn for years in human services on opiate issues and cannabis regulation and the medical program. And I cover reproductive health in terms of the abortion laws. And so that's why I'm with you today.
Great. So let's do some introductions. Thanks for the reminder that you haven't been in. So you want to start with Art?
Art Peterson, you know me. Clarendon, Wally, West Rutland, Rockland.
Leslie Goldman from the Bells Falls area.
Daisy Rebecca, I represent Winnie's.
Auburn from Barrytown, a part of Williamstown now.
Lori Hood in the City of Essex Junction.
Alan DeMar, Enosburg and Montgomery.
Melanie Carpenter, Kate brought me by.
Yep.
And Bobby Farley-Shrubio, Barnet, Reigate, Waterford.
Great. Well, pleasure to meet you. So I'm going to, rather than do a typical walk.
Oh, I'm sorry. I forgot Mari's on the line.
Hi, Mari.
Hi, Mari Cordes from Lincoln, right behind you.
Thanks, Mari.
So thanks for that. And instead of doing like a traditional walkthrough, because I think there's some sections in here that aren't necessarily that relevant to the work that you're doing, and I kind of want to make sure that I have some time to answer any questions and give some consideration about how S37 works with H89. So H89, which passed the House before, I don't even know.
Yeah, before crossovers.
Yes, it's been a little while.
Yeah.
It's more focused on the criminal and civil procedures and court procedures related to this issue. So when we're talking about, so this is often, H89 in particular is often referred to as a shield bill. There are 9 other states that have passed shield bills since, and it started, I think Connecticut was the first one last year after the Dobbs decision came out. And there are, I think, Washington and Colorado, it's at the end stage. I think in Colorado, it might actually be sitting on the governor's desk waiting for a signature. The idea behind this is that because there are some, as we know, real disparate policies and laws within the states now regarding reproductive health care as well as gender affirming care. We're coming up with a conflict of laws between the states. So generally there's something called the full faith and credit clause of the US Constitution. And the basic idea behind that is that states are to give full faith and credit to the acts and judgments of other states. And so, when you think about it, the idea is that, if we didn't do that, then it's going to impede people's ability to move around the country. And if you didn't require that, then let's say taking like a family law situation, I have, I was married, we divorced, we share custody of our children, and we have a custody order in place that was issued by a court here in Vermont. If I could just decide that I'm going to move across the Connecticut River and say, all right, kids are going to come over here with me and, I'm just going to ignore that Vermont order, then it really would create a lot of chaos. And so in general, the acts and judgments of other states are to be recognized. Now, there's a lot of nuances in there, and I don't want to take you down the rabbit hole of full faith and credit. But when it comes to the acts of other states, we're not required to apply or adopt the laws of other states, because then that would be a mess too, is right. Just because somebody comes here, especially if that state's laws are really against the public policy of what we have here, the full faith and credit clause doesn't require us to adopt that. In the case of judgments, it's different. And for the most part, states do have to recognize the judgments in other states.
You define judgments.
Judgment is, so if there's a court decision, there's a court ruling. So let's say in the case of, have y'all talked about SB 8 in Texas and civil ability? So typically, we're seeing there's a lot of creativity out there around these issues, and we're seeing a lot of statutes doing things that we haven't really seen before, in the sense that they're reaching beyond their own state borders to allow people to sue civilly to enforce those state laws, or you're seeing criminal prosecution for things that are legally protected here in Vermont. So Texas was the first one that passed one of these civil statutes, and it's commonly, the bill was Senate Bill 8, so that's typically what people refer to it as. And what it does is, so there is a ban on abortion in Texas, but rather than the state being the enforcer of that ban, and it specifically actually says the state is not, no state officer is to enforce that ban. It's up to individuals, and it can be any person. And it creates the ability for someone to file civil litigation against a person for either performing or essentially facilitating or aiding someone in obtaining an abortion. And there's a lot of questions about the scope of it. Who would that apply to? Would it apply to, let's say, an abortion fund that gives someone some money to be able to leave the state and go to a state where it's legal? Would it apply to the family member who drives that person to a clinic in another state? Those sorts of things. What's unique about this is generally when you think about the ability for someone, if you have a case against someone, you have to have suffered some kind of harm that you have to prove, right? So get in a car accident, whatever, I've been harmed and I'm going to go after the person who harmed me. It's different in this type of civil suit because the person who is empowered to sue and enforce the abortion law does not have to have suffered any harm personally. And that is one of the reasons why it's very constitutionally suspect. And I raise that because one of the areas where states don't have to recognize the judgments from other state is if a judgment is what's called penal in nature. And so that is essentially meaning that Vermont doesn't have to apply punishments from other states, right? And so I think there is a decent argument that the SB 8 legislation, and there's other states around the country that have adopted that, could be considered penal in nature because, again, the person who is suing has not received necessarily any direct harm. Maybe they have, but that's not required under the statute. And so really, and Texas was pretty open about why they were doing this way. It's in the legislative record, and they talk about it's basically to kind of avoid federal court scrutiny on them being state actors. So this law was adopted prior to the Dobbs decision coming out. And so I think in a certain circumstance, and all this stuff, I have to just give the caveat. Honestly, we don't know. We're going to have to see as this stuff percolates through the courts and we see what kind of rulings are coming out. But so in that kind of case, we have a provision in H89 that says we do recognize judgments from other states, but we don't recognize ones that are penal in nature. We don't recognize them if the court that handed down the judgment did not have jurisdiction to order, and that's kind of a given anyway. Or we don't recognize them if the defendant was not afforded due process. So an opportunity, so they've been notified, they've had an opportunity to be heard and participated in the process. So those are the three circumstances when we would not recognize an out-of-state judgment. Otherwise, we're required by the Constitution to do that. But that's not the case when it comes to statutes, where we have some room to maneuver and some choice in there. And in H89, there's several places where the bill states that it is the public policy of Vermont that people are legally entitled to obtain reproductive health care and gender affirming care, and that attempts to interfere with that right are a violation of our state's policy. And so that's something that people can fall back on and say, we don't have to recognize that. There's another provision in here that talks about how when there is legally protected health care at issue in litigation, that Vermont will apply Vermont law. We're not going to, so if, we have a litigation involving someone in Texas, and it's going to be disposed of here, then we would apply Vermont law. And then another basic, I think, that came up was y'all were talking maybe about extradition issues, and if someone, there was a request for extradition. Extradition is when there is the governor of a demanding state is seeking the return of someone who is located in the other state, and there's a formal process that it goes through. Vermont is part of an extradition compact with other states. There is also a provision within the U.S. Constitution, the extradition clause, that requires that. Again, thinking back to my original example, if it was, if I have to cross the Connecticut River, again, if I committed a criminal offense here in Vermont and I could just cross the bridge and they can't touch me, well, there's some problems with that, right? And so that the idea is that you have a duty to return the person who is a fugitive from justice in the other state. There is an exception to that where the state has the ability to choose its own policy around that. And that is if the person who is being sought, so let's say Texas is seeking to extradite a Vermont physician who has performed an abortion in Vermont. If that physician was not legally present in Texas at the time of the offense, and then fled Texas to come to Vermont, then we are not required to extradite that person. However, if they were present in the demanding state at the time of the offense, and then they left to try to escape being arrested or prosecuted, we have no choice but to return that person to the demanding jurisdiction.
Are you ready for questions, or do you want to keep going?
I'm just trying to think about, I was just trying to hit some highlights, and then would you like me to, can I just go through and show you a few little provisions in here that I think after talking about all of that might kind of help, and then we can go to questions?
And if you have questions, just write it down.
And so I just wanted to mention, and I'm sure that Jen and Amron have talked to you about this already, is that the plan, and so H89 is in Senate Judiciary right now, and we're doing markup tomorrow in there. One of the amendments that we're doing is we're taking the definitions in section 1 of S37 and replacing the definitions from H89. And that is because the two bills started out with the same definitions, but in the process of S37 being in the Senate and the House bill being in House Judiciary, the House bill was moving a little faster. And then we started talking about the definitions and working with folks and came up with a better way to kind of break it out and say it that we thought was clearer. And so we're going to substitute those definitions there. But I would just like to go over the definition of legally protected healthcare that is in S37 that we'll be using for both bills. I think it'll help, if you have a refresher, it'll help with the discussion around the questions. So if I'm looking at S37 and you're looking at section 1, which again is establishing some definitions in Title 1, which would apply throughout the statutes, and we look at the definition in subsection B for legally protected healthcare activity. First one is easy. So it means the exercise and enjoyment of a person's right to reproductive healthcare services or gender affirming healthcare services. And we're talking about rights that are already established here in Vermont. We're not creating any new rights with regard to this type of healthcare. On subdivision B1B, this applies to anyone who is assisting a person in obtaining that type of healthcare. All right. So it could be a provider, it could be someone who is providing transportation, it could be a family member who's helping them. So that's applying to people who are assisting someone. And if you look at the language, let's see, if you have on the same version I do as passed by the Senate, page 1, line 21. Where it says, provided that and then you go to the top of page 22, the provision of such healthcare service by a person duly licensed under the laws of this state, so Vermont, and physically present in this state shall be legally protected if the service is permitted under the laws of Vermont, regardless of the patient's location. And so I know that has been an issue that has come up for you in dealing around licensing, and that typically the default is that it's considered to be the patient's location and not the provider's location. And so I just want to note that. So when we go in and we start talking about these other scenarios and abusive litigation, we recognize that we're talking about that the provider is physically present here. The patient does not have to be physically present here. Okay?
Do you have a clarifying question, Art?
Yes, I do.
Okay.
On B, Michelle, I don't see where the language would apply to like a family member or somebody, because it sounds like they're duly licensed.
Well,
In terms of,
So let's hold that, because that's more than a clarifying question. So let's just hold that, okay, and keep going for a moment.
okay. So still on page 2, so we're looking at subdivision B1C. This is the bit about insurance, which is what we broke out on the other definition. I'm going to skip over that because insurance intimidates me. And I think you've already got Katie and Ameren, Jen and Ameren for that. So I'm going to move down to subdivision 2 there. So B2, and this is just saying, and it says it in several places in H89, that if something is actionable here in Vermont, this is not to be interpreted to then give a shield to that. So if you think in terms of a med mal case, right, and someone has been harmed by substandard care that they received in violation of the standards of care that have been set forth by whatever board it is that regulates that practitioner. If they would be able to bring that suit here in Vermont, it's not prohibited by this. It's not looking to protect against that. It's looking to protect against, and then we'll go into the definitions of abusive litigation that is seeking to interfere either with someone obtaining or providing legally protected health care here. Then the next one is subdivision 3. And this is the provision that addresses telemedicine. So we kind of address it a little bit up there at the top of the page. And then you'll see that we just restate that a provision of healthcare service by a person duly licensed in Vermont and physically present in Vermont is protected regardless of the patient's location. And then you have the addition of or whether, regardless of whether the healthcare provider is licensed in the state where the patient is located at this time the service is rendered. And again, this was a policy decision by the House when they passed this legislation earlier in the year. And so an instance this might be is, let's say you have a Vermonter who is attending college in a state where gender affirming care is prohibited for under 19. And they have their providers here in Vermont, and they work with those providers. And as I'm sure you've probably heard from testimony, someone receiving gender affirming care that can be over the course of many years, not just, when we're talking about abortion care, tends to be very kind of finite in time. And so that person could be taking a medication or going through counseling or things like that. And then they're in their other state. And let's say they have a question about their medication. Oh, I'm having a headache. I need to talk to my provider about, or do I need my meds adjusted? Or I'm having I'm stressed and I need to talk to my mental health counselor or whatever. And they have that established relationship with their provider in Vermont. This is not authorizing that provider to be practicing without a license there. That state can still do, we're not telling other states at all what to do in the other states. This is just about shielding Vermont folks from outside action, okay? So this is not an authorization to practice without a license in another state. This just says that if it's in the area of legally protected healthcare, so those two types of services that are provided, as long as the provider is here and they're licensed here and they're not violating standards of care here and everything they're doing is legal here, if their patient is on a trip and they need to talk to, they're traveling around the country or they're in college or something like that, and they need to communicate with their provider here in Vermont, then Vermont is going to shield them on our end. And the other state can do what it wants. And they could, go after them on licensing. They could, if there's a criminal statute, they could go after them on criminal statute. Somebody could sue them civilly. But Vermont is not going to help. And that's where there's a number of other provisions in here, like if it's abusive litigation, then Vermont is not going to subpoena documents to send to the other state. We're going to say you can do what you want. Your laws are what they are. And if someone undertook the risk and provided care without a license in another state, that's up to them. But we're not going to help you go after them because that type of care is legal here. Okay, and so I think if it's okay, I'm just going to start on the abusive litigation one, and I'll skip over SLAPP suits. I don't think that those are going to be used very often. But I can always go back to stuff, and I'm happy to have conversations with folks offline if you don't want to take up committee time, but just meet with me and have a chat about any of these provisions. So if we're looking at H89 is passed by the House, and we take a look at page 3, and you'll see at the bottom of the page, abusive litigation concerning legally protected health care. And you'll see the definition, new definition of abusive litigation. It means litigation or other legal action to deter, prevent, sanction, or punish any person engaging in legally protected health care. And you look at the top of page 4, and little I is basically filing a civil or criminal action based on legally protected healthcare that occurred here in Vermont. Okay, and so again, we're considering it to have occurred here if the provider is here and in compliance with all Vermont law and they're providing that service. Okay, so that's if somebody files a suit. So that could be an SB 8 litigation. It could be a criminal prosecution. It could be a licensing action. And then the second one, little II, is attempting to enforce any order or judgment issued in connection with the action. And you'll see subdivision B right under that is that a lawsuit shall be considered to be based on conduct that occurred here in Vermont if any part of any act or omission involved in the course of conduct occurred here in Vermont. So there could be something that's out, that part of the care occurred outside, like in the circumstance that I was talking about, where you have to call and follow up with your provider about medication or something like that. That doesn't then negate the recognition that the care occurred here.
Did you have a clarifying question?
I do. I just want to understand how the legally protected healthcare activity applies in S37.
Okay, so
Is that-
hold on.
that's not clarifying?
I'm talking clarifying, like what page are you on? What row are
Okay.
you on? Let's hold the question.
That's not clarifying.
Okay.
So if you look at page 5, top of the page, and the new section 7302. So essentially what this is doing is providing folks an opportunity to countersue if they've been sued involving abusive litigation. So you always go back to that definition of abusive litigation. So in the SB 8 circumstance, if someone has, let's say, they live in Texas and they have come to Vermont to stay with family and receive, abortion services or gender affirming care while they are here, and someone in Texas files civil litigation against that provider. Then what this does is it allows the provider to countersue the person who has sued them, because you'll see at the beginning there where I talked a little earlier about the public policy exception to recognition of out-of-state acts, is that you'll see here in subsection A, it talks about Vermont considers interference with legally protected healthcare to be against the stated policy of Vermont. And so essentially, if someone files abusive litigation, then you can see down in subsection C, they can initiate a civil action back against the person who has sued them for injunctive, monetary, or other appropriate relief within 6 years after the cause of action accrues. And so injunctive relief, injunctive just means kind of you're asking the court to stop something. Monetary is obvious. It talks a little bit, if you look at page 6 at the top of the page, talks about damages that are available. So if they succeeded in the countersuit, it could include damages for the amount of any judgment issued in connection with abusive litigation and any other costs for like lawyers' costs or things like that in defending themselves. So if you think about if somebody filed an SB 8 litigation and then Texas court issued a judgment against the Vermont doctor, right? And then as long as it was issued by a court with jurisdiction, there was due process involved. And then there's always the question about whether it's penal in nature or if it's, but let's just say for this example's purpose that we're going to ignore that one. And there was a judgment issued in Texas. Then the plaintiff sought to domesticate the judgment here in Vermont, meaning that they want to record it here in Vermont to have it enforced here in Vermont. And it says, okay, it's a $10,000 penalty that person would get for suing the person for violating Texas's abortion law. And maybe they're suing for lawyers' costs or whatever else it is. The person here, the Vermont provider, in their countersuit, if they are successful in their countersuit here, can say, okay, I want that $10,000 back. I want all my lawyer's fees for having to fight this and all of that sort of a thing. Again, so just reiterating, there's nothing in here that, trying to think of how to say it. It's where Vermont or Vermonters are necessarily like the initiators of this, all this court process and litigation. It's all about responding to actions based on statutes and litigation that's coming from outside states that have different policies. If you look at subsection F, still on page 6, this is, again, I mentioned earlier, if a cause of action exists here in Vermont, this is not going to shield that. So if somebody provided you with reproductive care that was substandard and you were harmed by that, this is not in any way going to protect that provider from that type of litigation. It's only if it's abusive litigation fitting that definition, and the abusive litigation is intended to deter or prevent or punish someone from engaging in legally protected health care. There's a couple exceptions there, just like for attorneys. So, anybody who's got a client and is either a plaintiff or a defendant's attorney, that, that doesn't, they're doing their job according to their license. So it doesn't extend to them. So still page 7, I already talked to you about foreign judgments and we must recognize foreign judgments except for those 3 scenarios where I talked about. The next section, 7304, testimony and documents. So this is that stating that a court is not required to order a person who's either domiciled here in Vermont or found within the state of Vermont to give testimony or produce documents or anything like that. So while full faith and credit requires us to recognize the judgments, it doesn't require us to adhere to requests around subpoenas and summons, and things like that. Okay, so that is something that the state has discretion against. And so when it comes to abusive litigation, if there's a request to domesticate an order from another state and they're seeking to have somebody testify back in Texas against the provider, or they want records that are either kept by the state or a provider or somebody, and they want to use that in the prosecution of that provider in Texas, this is saying we don't provide that information. Again, it's just saying you're going to do what you're going to do, but we're not going to cooperate with that because it's against our public policy. Page 8, and I think I already touched on this too, is that when we're talking about abusive litigation, Vermont courts are going to apply Vermont law. Again, we have the option, there's discretion within full faith and credit that when something violates state policy, then, there's U.S. Supreme Court case law that says, just because another state has another law and then there's a kind of a conflict of laws, it doesn't require us obviously to just throw our laws out and adopt the other states in determining the action. The next section, section 7306 on non-cooperation, just kind of goes with the other provisions. And so this states that no public agency or state employees or officials are to, and I want to note knowingly, there's a mens rea, knowingly, so somebody might actually provide information in one of these cases, but maybe they're not clear at the initial onset that it's involving abusive litigation, and then they later find out that it is. So, but they may not knowingly provide any information or expend money or resources in assisting another state with regard to abusive litigation against someone here. And then there are a few, and it applies to any interstate investigation or proceeding seeking to impose civil or criminal liability upon a person for either for providing the protected care or for assisting someone in obtaining that care. And so again, it may be that there's kind of a innocuous request that comes in, or something that we were talking about in judiciary a lot was if a warrant comes through and law enforcement receives it, they may not have any of the background about that, and it may not be clear at that moment. Other states are experimenting with doing something that kind of requires there to be a statement to that fact. So when it comes into law enforcement, they know one way or the other. And we're kind of, I think the approach of judiciary was like, well, let's see how that kind of shakes out, and then we can always go back and tweak it. But so if someone does provide that information erroneously because they just didn't know, they're not going to be held accountable for that. It's just that in general, you can't do it if you know that that's what it's about. So I think that those are, there's other provisions that I can talk about, but I think I've kind of covered extradition and.
I want to make sure we have time for questions.
Sure.
So, great. So Bobby, I think you had a question, and then we'll go Art and Leslie and Brian.
Oh, it's been
Sorry.
No, it's not a problem. It's just I'm thinking of hypotheticals.
Sure.
And let's say that a Vermont doctor provides abortion care to a patient in Texas through telemedicine, so they're physically present in Vermont when they do this. But then let's say this may sound silly, but they're flying on a plane to Mexico,
right.
and the plane is unintentionally diverted to Texas because of
unintentional. I would say don't take a connecting through Texas.
Yeah. But there's emergencies where a plane has to land somewhere you didn't plan on going, and all of a sudden you're in Texas. Could Texas law enforcement come and pluck this doctor off of the plane?
Yeah, we can't do anything in terms of protecting our folks beyond the borders of our, of Vermont. And so healthcare providers, if they are, running afoul of other state laws that are contrary to ours, have to do that knowingly and decide whether or not they want the assumption of risk. And I think there's, if you haven't had the conversation yet, I'm sure you will, but we had it in judiciary about, how do we how can stakeholders work to make sure that providers are getting the best information so that they can make the right choices for themselves about what they're doing around that. And so I think the medical society and other folks are kind of, sorry, you're like, don't say that. But because, that is an issue. Just downstairs in Senate Judiciary, we're working on H89. And this morning they had Bob Paolini come in from the Vermont Bar Association. And the request from Senator Sears was, hey, are there any pro bono attorneys who might be willing to help out in this? And Bob said, yeah, because I think, there is some real interest in that. And we talked a little bit about a program in Massachusetts that was organized by the Massachusetts Attorney General's office in collaboration with the women's division of the Massachusetts Bar Association, as well as the Massachusetts ACLU, and a couple of law firms collaborating to be a resource for people in Massachusetts on these issues. So if they have questions, like that, hey, I'm going to Mexico. What if somehow there's a thunderstorm and I got to land in Dallas? That they could go to people with legal experience in these areas and hopefully get some help there.
Just a quick follow-up. Now, if this was a civil thing, like, for example, one of these self-deputized anti-abortion bounty hunters had a $10,000 bounty on one of these doctors, there's nothing they could do about that if they were on the ground in Texas. Like, would Texas law enforcement enforce a civil? Okay.
No.
I just make that. That's more of a general question.
You just don't.
So there wouldn't be a mechanism, but if it was a civil penalty.
Right.
But there would be a mechanism if it was a criminal penalty.
Right.
Yeah, okay. I just want to clear that up. I'm done.
Yes.
All right.
Just a couple questions, Michelle. First, maybe just a procedural one. Did you say you were talking about this downstairs with judiciary now?
With Senate Judiciary.
H89.
Oh, Senate Judiciary. Okay, I was
That's
thinking
okay.
about it.
No, because the bill, crossed over.
Correct,
Yep.
and that's, I got mixed up. With that in mind, are you involved with S37 also? You wrote that too, or?
No, that's Amarin and Jen, but we do, talk and coordinate, but they are really the experts on S37.
Okay.
I don't know much
Right.
about licensing and those types of things.
My question may be more for you, Lori. How are these two going to fit together, assuming they both go through the system? Are they both going to be separate bills and we take stuff out of both since some of the stuff is similar?
So the definitions would be the only, and correct me if I'm wrong, the definitions will be similar in both bills. I think Michelle said that in the beginning. Otherwise, they are two separate bills.
Two separate bills with separate stuff in it.
Right, we're dealing with licensing and insurance, and they're dealing with litigation.
Okay. The other question I had was around non-cooperation. What other things do we have non-cooperation with? Do you know of any others where we specify we won't cooperate with another state over an issue?
I don't know exactly what the policy is, but what I do recall is it came up around issues around immigration status. So it's not the same as this. But that issue was discussed around local law enforcement working with ICE.
Okay.
So if someone was, let's say, stopped for a driving infraction, right, about them not going and seeking information that's they then are intentionally sending to ICE and kind of working as a mechanism for enforcement of federal immigration
Has that
law.
ever been challenged anywhere? I'm surprised that's legal.
I'm not your
No,
immigration person, sorry.
Yeah, no, I understand. Thank you.
Did you have that question about the family?
Pardon me?
You had a question.
It's,
You good?
that's okay.
Okay, Brian?
I'm trying to, I see how federal law is, federal requirements or law are mentioned several times, like, we say something except for federal, and it's because federal government would, federal laws and rulings would overrule the state. And so what might happen if, like courts continue to overturn other states' laws, like, for example, like, there was this recent ruling where, in one state, a federal court, I might get it a little wrong, but a federal court ruled one way about emergency contraception, and then in another state, another way.
Right.
And so it may escalate to the Supreme Court. So like, if these legal battles play out over the next few years, if the Supreme Court rules that there's no such thing as legally protected healthcare, like let's say someone sues the state of Vermont and then, or there's a suit in Vermont and a suit's another state, ultimately, could all of this just be?
It's really it's gonna be on a case by case basis for all of these things. Why we put the language in there federally about recognizing less contrary to federal law is really just kind of like, we're just saying, hey, we see you. Some court may interpret this in a way that we don't necessarily interpret it. We're not saying, like, we get it. We are preempted, perhaps. And because there's just so much litigation around all of this, I mean, even just in the case that you're talking about around the pharmaceuticals, and you have two federal courts, right, with completely, opposing there, is everybody's still, the DOJ filed a motion saying, well, what are we supposed to do? So I think, it's always a little uncomfortable for us to just be like, I don't know, but it's really, this is kind of the landscape that we're working in, because things like a lot of the stuff that this bill is responding to are things that we haven't really seen before. So like if you just, an analogy I think that is a helpful one for me is that if you think about it, let's say, so casino gambling is legal in Nevada, right? It is not in Vermont. Vermont, if somebody who's a Vermonter, if I go to Vegas for the weekend and I gamble all weekend, and then I come back to Vermont doesn't have a law that's going to prosecute me for gambling in the other state, right? But yet that's what some of these laws in other jurisdictions are looking to do. And so it's really new. And so we're just going based on stated policy of the General Assembly and their desire to protect this type of healthcare that is already illegal in Vermont, and try to kind of shield it from outside jurisdictions kind of monkeying around with it.
So just the final question related to that is there any scenarios before that happens? Like that is such a vague thing. Before a like sort of higher court federal ruling would change anything, is there any scenario where federal agents could be used by another state to come into Vermont and try to like extradite people or like arrest people or detain people for these legally protected health care?
I would have to really think about that, but my first thing is no, this is really just a fight amongst the states.
So the federal government would not get involved until there was either a change in federal law or...
I mean, federal government, when you're talking about the courts, you're talking about, they're going to be ruling on constitutionality of these statutes. They're going to be ruling on application of law, right? Who has jurisdiction, those types of things, right? And so that's really what is complex. Whether or not there's anything that the federal government, I mean, I would have to think about that. I don't want to be too quick and flippant in saying no, but nothing comes to mind.
Okay.
The one area that it does play into obviously is, in talking about prescription drugs, right? And how that is all going to play out, which is anybody's guess.
You good, Brian?
Yeah, I'm just, I'm just curious, like what about
Yeah.
it's like thinking about what all the potential consequences may or may not be.
Right. I mean, I think I could say that because this bill was really, we drafted something and it was introduced, but then House Judiciary spent a considerable amount of time working with it and working with witnesses, working with Judge Zone at the court and other people to really, and the Attorney General's office quite a bit. And, the testimony amongst all those folks is that, from the AG's office is they view this as a very constitutionally defensible. We didn't, there were some people who said, well, if somebody performs an abortion in another state, I don't want to send them back to go to jail, but that's, we're pretty clear on that's not really a choice that Vermont has, right? So we've really tried to figure out how we can, within the parameters of constitutional rights and the current jurisprudence, which is changing all the time, say this is what Vermont can do to protect its folks, and this is what you can't do.
Great. Anyone else have any questions? Thank you very much.
And like I said, anybody can shoot me an email if you've got a question, or I can set aside some time if you are trying to understand something, because I know that you get a lot of constituent stuff. And while I do not do constituent work, I'm happy to help you on whatever you want to come in terms of a response to people's inquiries or something, to make sure that you're legally accurate about what's in the legislation.
Great. We appreciate that.
Sure.
Thank you.
Yeah, thanks.
Here's Lauren. Okay, so we're going to now take a break. We're going to switch right to our next topic, which is Lauren will be joining us. Let's see, we are on section 8, I believe. Hi, Lauren. Good to see you again.
Morning.
So I believe we are talking about potential language changes that you have for us, correct?
Yes, on section 6.
And 6. All right, so that is page 9. And did you send those to us? I think you did, right? That's how we posted.
I submitted testimony on section 6. We've made some slight revisions since I submitted the testimony, and I provided the proposed language. I've worked with and Ledge Council.
Okay, great. I'm just going to turn it over to you then.
Okay. So my name is Lauren Lehman. I'm General Counsel of the Office of Professional Regulation, for the record. And so today we're talking about S37 in section 6. That section addresses unprofessional conduct in Title III of the statutes. Title III applies, the provisions in that chapter are the umbrella provisions that apply to all OPR regulated professions. So it would encompass all the healthcare professions that are licensed by OPR and regulated by OPR. Our proposed changes are consistent with recommendations from Planned Parenthood of America and would incorporate a slight addition to an existing standard of unprofessional conduct we already have, which is the willfully making or filing false reports. This would add a provision onto that says at the end, or willfully providing inaccurate health or medical information to a patient, including purposeful misrepresentation of a patient's health status. So again, that would be incorporated into our unprofessional conduct standards. If a complaint was filed, our prosecutors would be able to look at the facts alleged and see if it met, if it constituted intentionally providing inaccurate information, health information, and if so, file charges against that healthcare provider's license.
And so Lauren, where would that go? Or maybe I should look at Jen. Where would that go in the bill?
Jen Carvey, Legislative Counsel, and I think it would go in section 6, probably in some language you can't see right now,
Okay.
because it's being,
Drafted.
there's stars.
Okay.
Added in somewhere?
Be
So it
added.
would be added into the existing laws. If you can see at the beginning of section 6, it says previously section 129A is amended to read, so we're already in that statute.
Oh, that we can't see above the stars,
Exactly, you can't see
yeah.
those stars, exactly.
So subpart A of 129A that Jen just referenced has a whole list of, I believe, 28 things at this point in time that constitute unprofessional conduct for any profession. And this would modify one of the existing things that it constitute unprofessional conduct and add another. And the bill already includes a modification or a new section to that bill in addition to sub A.
So I think you said this at the beginning, and I apologize. So this applies to any entity that OPR regulates?
Correct. So, and I'll speak later, it does not touch on the professions that the Board of Medical Practice regulates. So the committee might want to reach out to David Herlihy or the Board of Medical Practice to see if it might be appropriate to add a citation into their statutes for the professions they regulate, which are medical doctors, allopathic medical doctors, podiatrists, physician assistants, and several others. So
I think, Lauren, sorry, we have a question. Do you mind? Mari?
Thanks, Lauren. So just for clarity about the disciplinary action, if there's a file claimed of unprofessional conduct, there's a range of potential disciplinary action that could be, on one end, just the conditioning of the license, temporary suspension, permanent suspension of a license, all the way to criminal action. Do I have that right?
yes, almost. There's no criminal action. So we can only we might work with the state's attorneys or prosecutors and provide them with assistance in pursuing criminal actions in a criminal court in Vermont. But OPR's jurisdiction is limited to reprimanding the license, which is on the lower end, to revoking the license, which is on the higher end, and then in between condition, suspend, etc.
Okay, thank you.
Of course.
Alan?
Thank you. Don't we have laws now that cover misleading and deceptions in different settings, with clinics and hospitals and whatever?
So we have this would be an addition on an existing requirement that already makes it illegal or, it already makes it unprofessional conduct for somebody to willfully make or file false reports or records, willfully impede or obstruct making appropriate reports or records. Fraud is included as well. So theoretically, yes, it could be included, but the more specificity here provides very direct guidance to OPR's prosecutors that fraud also includes willful misrepresentation of health information. That would be a fact-based argument that a prosecutor would need to make, that the willful misrepresentation of a health status or medical information constitutes fraud, because fraud is a very broad term. So this provides more clarity and guidance that that act is incorporated into unprofessional conduct.
Art?
Yeah, just to be clear, the genesis of this came from Planned Parenthood.
Planned Parenthood, we've spoken with them and they wanted more specificity about, about willful misrepresentation of healthcare information in general.
Why does what they want matter to you?
It's a recommendation, and if it's recommended for patient protection, we like to recommend it and put it out there for your decision making.
Right, so it'll be a decision, so it'll be incorporated into the bill, and when we do our walkthrough tomorrow, we will decide as a committee what we put in and what we don't. All right, I think that's everything here, Lauren.
Great. So then there's another addition as well to the 129A. This one's not a modification, but a new unprofessional conduct standard. And it is providing or claiming to provide services or medications that are purported to reverse a medication abortion. This is very specific to any claims. There's been some modification to the language since I submitted my testimony, but I can revise that if that's helpful. And I've spoken with legislative counsel about this, but we would recommend that there be an additional unprofessional conduct standard related to claiming or providing services that allege or purport to reverse a medication abortion.
Any questions on that? We'll see the language tomorrow when Jen puts it in. Go ahead, Art.
Is the idea that you don't think that's doable? Is that why this is subject to some sort of restriction?
My understanding from outside research is that that is not doable. So it is, again, a misrepresentation to patients.
We heard that from a doctor.
Okay, all right.
Okay.
That's our full recommendation for the Section 6 additions. Again, just highlighting that it only applies if it's in Title III, as in Title III, it only applies to OPR regulated professions. And if the committee wants to extend it to also those professions regulated by the Board of Medical Practice, additional changes will need to be made.
Thank you.
Section 8, I think we're still in discussions about how or if that would be modified. So OPR would like to wait to testify on that. And that's all I have on those two sections, but I'm happy to answer any questions.
So on maybe we already did this. Oh yes, we did 11 and 11A the other day. Okay, so we're good. Any questions?
We're gonna have a chance to ask questions tomorrow on this, whenever it gets.
Tomorrow will be a committee discussion, questions with legislative counsel. Yes. Not OPR. So your questions for OPR.
Well, maybe the question is for them then. My question is this: in Section 8, Planned Parenthood comes forward with some recommendations, but they're specific only to pregnancy service centers. Why is that?
Section 8 is actually in that language is specific or is part of the Attorney General's office regulation. So I suspect those questions can be answered by them or in further discussion.
Attorney General.
Oh, okay.
Just a follow-up on that, is Planned Parenthood considered a pregnancy service center?
I'm not
We
sure.
can ask, we have Planned Parenthood in at 11:30. That's a good question for them. Any other questions for OPR? Great. Thank you, Lauren, very much. Have a good rest of the day. And we are on break.